Thank you all for the opportunity to talk with you today. My name is Emma Llansó. I head up the Free Expression Project at the Center for Democracy and Technology. CDT is a nonprofit public interest advocacy organization that fights for human rights and civil liberties in internet law and policy in the US, Europe, and around the world. We were founded in DC in about 1994, so we're one of the older internet policy NGOs out there, and we've had staff in Brussels for the past 6 years or so, as it became increasingly clear to what was a US-based organization that a lot of the law and policy and kind of standards for how to ensure human rights in internet policy was really going to be led by European activity. My work in the Free Expression Project focuses on a couple of different areas of law and policy, including sort of the obvious fundamental rights protections for freedom of speech. In the US, that's the First Amendment, or Article 19, Article 10 in the ECHR, and also a lot of work on intermediary liability laws. So what are the rules and standards for when, if ever, content hosts, search engines, access providers, and other technical intermediaries are treated as legally responsible for content authored by third parties. And especially over the past couple of years, a lot of our work too has focused on working directly with companies, advocating at tech companies around their policies and practices. What are their content moderation regimes? How do they provide notice to their users about what is happening to their content? What kind of transparency reporting they do? We joined with a number of other organizations earlier this year in putting out a document called the Clara Principles for Transparency and Accountability in Content Moderation, which was sort of a summary of a lot of the kind of leading thinking about what people in general, what advocacy groups would like to see from content platforms as far as providing more transparency, more notice, and greater opportunity to appeal their decisions for their users. So as Sanja mentioned, we're talking in this session today about the problem of private law enforcement, which raises the initial question of, what do we mean when we say private law enforcement? There's been, and there have been a couple of answers to this question over the years. There's been a lot of discussion around the question of enforcement of companies' terms of service and their community guidelines. So the pure voluntary content regulation activity that platforms large and small engage in. This is a really important component of what shapes our information environment. But I wanted to focus a little bit more specifically today on circumstances where these private actors or other private actors are specifically called on to interpret, apply, or in some ways enforce the law of a nation. So truly putting the task of interacting with the actual laws around speech onto, at least partially onto the shoulders of private entities. Now this also can take on the name of sometimes self-regulation or co-regulation. There's a lot of different kind of models and taxonomies you could use for these different approaches, but I thought it might be most useful to us to just kind of talk through some of the different models that we are seeing play out here in Europe that have this component of having a private entity kind of pass judgment about the law. So the first example that I wanted to talk through is this concept of trusted flaggers. We've talked about this a little bit already today. I think several of the speakers mentioned the European Union's Code of Conduct on Countering Illegal Hate Speech Online. So this was a code that was developed between European Union, a number of big US-based internet companies, and consultation with several different NGOs focused on countering hate speech online, fighting back against hate speech and racism, to develop an voluntary agreement written out as about a page-and-a-half long code that platforms would essentially do their best to respond to notifications from trusted flaggers about illegal hate speech that was on their platforms within 24 hours. So the code was adopted, I want to say in 2015, so within the past several years, but several years ago now at this point, and was sort of a big step in really kind of taking seriously this question of the prevalence of hate speech online, the kind of application of different European Union member states' laws to that content, but also having this model of empowering nonprofit organizations under this code to say, you will be the entities that are trying to identify this content online. You will be sort of tasked with or given kind of a particular role of identifying potentially illegal hate speech, bringing it to companies' attention, and then the companies will do their own evaluation, typically under their own terms of service, or perhaps under the law. It's not always exactly clear about whether there is potentially a violation of law here. So we have in the system sort of both NGOs and companies being asked to at least informally weigh in or voluntarily weigh in on whether they think a violation of the law has happened. I think one interesting kind of, a couple of interesting things about this model. One, it sort of grew out of or shares some of the same nomenclature with programs of trusted flaggers that many social media companies have had in different ways over the years, where they realize that a particular user or organization is particularly good at identifying violations of the company's terms of service. So like the person reports content and the vast majority of the time the platform agrees, yes, this is a violation of our terms of service. There have been a couple of different programs. YouTube has had one where people who they notice are particularly good at matching YouTube's assessment of what their terms mean can get special kind of privileges for flagging content. Typically that involves things like having the limit on the number of flags you can return in a particular time period raised, so that where a regular user may only be able to flag 10 things an hour, a trusted flagger could flag many more. So it's interesting, I think, to see this this concept that was actually first developed by platforms themselves, of finding people who agree with them a lot of the time about what content isn't appropriate for the platform, now shifting character a bit and having the standard that the trusted flaggers are asked to apply actually be an external body of law that neither necessarily the flagger nor the company is the expert at interpreting. It's also interesting under the code of conduct on countering illegal hate speech online. I think an open legal question under this code is whether the notifications that trusted flaggers give to the companies constitute sort of legal notice under the intermediary liability regime that there is, of the presence of illegal content. Under the e-commerce directive, as we were discussing before, platforms will have an obligation under national law to take action when they have notice of illegal content. A lot of advocates, including CDT, have argued for many years that the only form of notice that truly identifies illegal content is a court order, because then you have an independent court having determined that, yes, this speech does violate the law. Notice may not need to be as fully formed as a court order, though. And I don't know of any cases, but if folks in the room have heard of them, I'd be interested to know of whether notifications coming from a trusted flagger have been considered actually true notice of illegal content. Let's see. So that's trusted flaggers. Another kind of model that we're starting to see that, again, involves this question of interpretation of the law is, as we've talked a bit about already today, the NetzDG law. And so NetzDG asks platforms or requires platforms to develop systems that enable them to, within 24 hours for content that is manifestly unlawful, remove that content after being notified by users, by trusted flagger or NGO types, by government officials, sort of notices from anyone that are indicated to be related to one of the 22 provisions of the German criminal code that are at issue in NetzDG, and to receive these notices, assess them, decide if they think the content violates the law, and take response pretty quickly. Obviously, this kind of model requires platforms to be the ones to interpret the law. The NetzDG removal reports or kind of notifications are not issued by courts. They are issued by kind of potentially anybody, so I guess potentially a judge on their time off. I think another important feature of the law is that they also, the potential penalties or fines are for kind of systematic violations of the requirements of the law. So if there's kind of a systematic failure to remove content that is manifestly unlawful, if there's a failure to provide required transparency reports, if there's a failure to provide the kind of reporting mechanism that's required under the law, that's when fines of up to potentially 50 million euros can be assessed. So it's this interesting kind of new legal structure that puts this requirement for adjudication of what violates the law on the backs of the companies. But it doesn't have provisions for kind of making a single mistake. Mistakes that, or kind of failures under the law that are systematic are where fines are contemplated. And I think it's been interesting to see, I think Peter mentioned that there was a lot of the companies who are operating in Germany put out their first transparency reports as required under NetzDG several months ago. Just some numbers from the YouTube transparency report that I think show a really interesting kind of blurring between their interpretation of the law or their interpretation of their terms of service under NetzDG is that, so they received in total about 214,000 reports that indicated, this is under this new German law. They took action against 58,000 of those. So that's a good 150,000 or so that YouTube decided didn't violate either their own terms of service or the law. Of the 58,000, 24,000 were in the category of likely hate speech, and almost 2/3 of those were things that YouTube took down first under its terms of service. So at the end of all of those numbers, and I'm sorry I don't have them up here on the screen, it would be easier to follow, that 37% of the things reported to YouTube under NetzDG were things that YouTube removed as, under their assessment, in violation of German hate speech law, which is, I leave that there for us to think about. It is not the concern of absolutely everything that gets notified to the platform will immediately come down. It's not a 100% removal rate. As a free expression advocate, I think that's a pretty positive sign. But I think it is also notable that the majority of the action that the platform's taking against hate speech is still under its terms of service, even with NetzDG kind of as a structure existing in law. And then the last example to walk through. So another interesting sort of shift in how we're thinking about this question of interpreting the law and interpreting what is a violation of law against speech are internet referral units. So these have been around in different countries for several years now. The UK, I believe, had the first one, started up back in 2010, and then in 2015, the counterterrorism coordinator for the EU recommended that more member states set them up. There's also been a referral unit set up at the kind of the Europol level. These are internet referral units or programs where authorities in countries or at Europol, typically law enforcement, will send notifications to platforms of content that the law enforcement officer thinks is unlawful, and the companies will then assess the reports under their terms of service, typically. So it's this another kind of interesting example of where the action on the law enforcement side of things is cloaked in law. It is made in reference to law. Law enforcement is not typically the entity in our legal systems that applies the law in that way, but they report what they suspect to be violations of the law, and then the company takes action against that, that material under their terms of service. These are kind of increasingly popular as ways to kind of deal with the issue of scale of potentially illegal content on online platforms. The idea of going through an entire full due process adversarial proceeding over every single piece of content that may be illegal is essentially impossible for courts to comply with. But it does leave us with kind of I hope, a good idea of what the problem of all of this private law enforcement is, which is that the traditional mechanisms that we have for accountability over applying and interpreting the law are really missing from a lot of these systems. And when I talk about accountability, I mean both of the private actor, making this decision, interpreting the law in some way, asserting that someone else's speech violates the law, but also of the government actors who are kind of behind or a part of or in some way involved in these different systems, but where the kind of the traditional mechanisms, including bringing legal challenge to their action, that typically help to keep them accountable for targeting somebody's speech, saying that someone's speech is illegal, a lot of the times those accountability mechanisms don't show up in these systems. And so I think there's kind of two ways to think about why accountability is such a problem in these systems. And the first is kind of the practical or technical sort of question of it's not always clear who is doing what, who is making which decisions according to which standards. So even the question of saying, this was your decision and you should be responsible for it, identifying who the you is, identifying what the decision was, can be very difficult. We do have transparency reports from many ICT companies and some governments around their efforts to restrict content online. It's been longstanding practice for tech companies to do, practice of at least the past 5 years, to do reports on the demands for content restriction or access to user data that they receive from governments around the world. So you may have heard of these called government transparency reports, and they've really become an industry standard in giving people an idea of how often and from which governments are companies receiving orders to take down information, close accounts, hand over user data. That's good, but they don't give kind of a complete picture of everything that's going on. Recently, a couple of companies, including Facebook and YouTube, have started doing more transparency reporting on their terms of service enforcement, which is, again, a very positive step. But I think most of us in this room probably feel far from having a total picture of how the big platforms, the medium-sized platforms, are affecting content online and kind of under what terms and standards. Some of that has to do with the fact that companies just report this information differently. So Twitter has a particular way of reporting the dynamic of getting a request from a government in and making decisions about that content under their terms of service. I think they were one of the first platforms to actually start kind of making it clear in their reports a couple years ago that is the dynamic at play, that often, and this is, I think, pretty much the case across every tech platform that I've talked to, when a company gets notified about some kind of problematic content on their platform, the first step, by and large, is to look at that content and see if it violates their own terms, their own community guidelines, because that is probably the set of rules that the company is most familiar with and most comfortable with. It's a set of rules that they've committed to applying globally across their platform. So if you make a decision under community guidelines, the content comes down worldwide, and is kind of in accordance with what the company thinks of itself as setting out to do. If something doesn't violate community guidelines, that tends to be where this assessment of, do we think this violates a particular local law, comes into play. And that's where you get into, as Peter was talking about, things like geo-blocking, making content inaccessible in particular countries, but still leaving it up for the rest of the world. And so that process, that way of making decisions for companies is very understandable from a kind of practical, how would you enforce community guidelines? How would you deal with getting demands from governments from 193 countries in the world? But it does make tracing the root of government assertion that speech is unlawful or private party assertion that speech is unlawful a lot harder to pin down. I also have to note that the tech companies at this point are far outpacing governments in the transparency reports that they provide. There's just nowhere nearly the same sort of systematic reporting from government agencies, from law enforcement agencies. For example, internet referral units, some of them, probably at this point, most of them are providing some data about the content that they are targeting under these programs, but there's still a long way to go on the government transparency side as well. But in addition to that kind of practical question of who do we hold accountable for what, there's also just this, I think, a bigger societal question for us to think about, which is that we don't really have pre-existing models for holding people accountable in this kind of dynamic, where we are dealing with actions taken against content at scale. We're dealing with a lot of decisions that are being made in a fairly non-public way. So you don't have the example of, the government prosecuting a case in court where the information about the fact that this law is being invoked is public. The opinion about how the law was applied is made public. You don't even have the dynamics of more informal censorship or content regulation, even just of decisions made by a newspaper about what articles they will or won't publish. Kind of interactions with ombudsmen at newspapers, other ways of kind of making the decision making in these cases transparent to the public, so that people can think about what is the material at issue, how are these laws being used, how is that affecting the information that's available to me or to the rest of my community. A lot of that is happening in ways that we, as people, haven't really had to grapple with before, happening at a scale that is really pretty transformatively new for our information environment. And happening in a way that the kind of raw transparency that we expect from a court publishing an opinion on every case that it hears is simply, again, because of scale, probably not even possible in this context. So I think it is very much worthwhile thinking about what other models of accountability we can and should be thinking of in this context of online speech. So I've touched on some of these already, but a couple of the particular challenges that we see around accountability is this question of access to remedy and appeals for people whose speech or access to information has been restricted. There are a couple of challenges here. One is, again, who is the correct target of your desire for an appeal? I think this can be a challenge for people when they're just sort of simply interacting with a platform around terms of service enforcement, but particularly when the law has been invoked against you and your speech somewhere in this process, where maybe it's an NGO thought that what you said was perhaps illegal. Maybe it's the company's assessment or a law enforcement agent's assessment. It's often not even clear to the user whose speech has been taken down, whose account's been deactivated, that was part of the dynamic. Often they will get a report that your content's been restricted under community guidelines or has been found to be unlawful in country X under this particular law, so it's limited there. And I think that bears thinking about a fair bit, that you have here people who kind of are having the law applied against them in a way that there's really no particular remedy for. Particularly, again, when some of the decisions taken against people's content is to remove them under terms of service, even the remedy of saying, no, my speech is not illegal, restore it to your site, is likely not going to be available if the company thinks that the post should have come down anyway under terms of service. This gets kind of to the broader societal point I was speaking about earlier, that this can potentially really be masking our understanding of how the law of our country is being interpreted and applied to us and to other people. Understanding that a particular NGO or a particular company is interpreting the hate speech law of Germany to prohibit X but allow Y is not exactly case law that's being sort of developed and available for people to understand. I think this dynamic is particularly important to think about as we have conversations about things like disinformation, or what are the ways that kind of companies' algorithmic promotion of certain posts above others, or certain websites or links above others is shaping our information environment. Those are important questions to ask, but systems that ask the companies to also interpret the laws against speech in our countries have some of the same sort of wide and hard to perceive shaping effects on our information environment that certainly raise concern. Then, and this is a particular consideration close to my heart, of this whole question of disproportionate enforcement of the law against certain groups or communities. This is, I think, an obvious concern in the application of hate speech laws or anti-blasphemy laws or laws against terrorist propaganda, when those laws are kind of used only against certain perspectives, certain views, certain groups or backgrounds. That seems to be inconsistent with an equitable application of the law and can sometimes reveal particular biases or viewpoint discrimination on the part of the enforcement agencies. When those enforcement agencies are courts or are prosecutors bringing cases, and that can be reviewed in a kind of a publicly accountable way, there is a potential check on the use of the law against particular communities. When the use of the law to kind of get the content takedown ball rolling, but not necessarily to have the law be the final arbiter of what comes down or what doesn't, again, we lose that ability to kind of trace that use of the law, to trace that kind of leveraging of what is in our legal systems against different groups. So we've seen Article 10 already today, but I also threw Article 13, right to effective remedy, up there, just as a way to kind of think about the challenge that these different models of co-regulation or private law enforcement pose. Everyone has a right to freedom of expression, and the limitations on these rights fall under the three-part test that's probably known to everyone very well in this room. And I think it's interesting to kind of to think through something like the code of conduct, and to think about whether and how it is inconsistent with or in tension with or just sort of doesn't fit into the framework that we think about permissible limitations under. So, is it provided in law? It is certainly it's not a piece of legislation, passed by a legislature and signed into law. It is an agreement, among government actors and private entities that is based on, interpretations of existing law. As far as access to remedy, if I'm remembering correctly, it doesn't provide any. It doesn't kind of note any particular commitment on any of the parties involved to providing an access to remedy, to providing an appeals mechanism. From my view, that makes it fairly deficient, if not in violation of Article 10 directly, at least certainly something that is failing to live up to kind of how we have looked at limitations on freedom of expression in the past. Thinking about NetzDG, again, there's this challenge of there's no determination by a court about the illegality of specific pieces of content. I think there's certainly questions around necessity and proportionality of this sort of 24-hour takedown response that we're seeing kind of echoed in a number of different legislative ideas right now. Is not necessarily a proportionate response in all cases for all types of potentially unlawful content, and may itself, put certain burdens on smaller providers or bias larger providers towards acting in a certain way that may not be commensurate with the benefit actually obtained from taking prompt response to content. And again, with internet referral units, it's interesting, I was checking out Europol's latest transparency report around the activity of the Internet Referral Unit, and they kind of clearly specified that referral activity does not constitute an enforceable act, I think partly kind of indicating that they should not be in the kind of, government actions, or they would prefer not to be considered to be in the government action space where the rules about how governments can pursue limits on freedom of expression would apply. That, I think, should give people pause as well, because I think the real sort of quote-unquote innovation in these different models is this blurring of lines between government action or action under the law and the privately developed content policies of internet companies. Should also note that under the US legal system, the companies have incredible leeway to craft their policies. They are both protected by the First Amendment as far as setting the terms of their content policies, and also by the US Intermediary Liability Protection Law, Section 230, which essentially gives them immunity from legal responsibility for almost every sort of user-generated content. So that the leeway that they have in crafting terms of service is quite broad, which means that they can be much more restrictive, certainly, than what the government could restrict under US law, but also for a number of other laws. I wanted to, at the final point to address is this whole question of automation in content moderation in general, but in particular in this question of private law enforcement. So again, probably no surprise to anybody in this room, there are enormous pressures on all sides relating to the scale of online speech. And I mean pressures on the platforms, obviously, to do more about the content that is available on their platforms and all of the content that people wish was not available on their platforms. There's also pressures, obviously, on government actors as well. I mentioned earlier the limited ability for courts to do a traditional process for every instance of potentially unlawful speech online. But also law enforcement obviously feels tremendous pressure to identify potential violations of law, in particular potential terrorist activity or threats of offline violence. And so all of these pressures, then there's also pressures from advertisers on content platforms about what is the material that their ads is showing up next to, and the kind of brand protection questions that many advertisers have, I think have an enormous amount of influence with content platforms. There's also pressure from users, right? Has been a growing movement among users around the world to try to get platforms to take things like hate speech and harassment more seriously. I think we've seen a lot of changes to how major social media platforms have dealt with these issues over the past couple of years through a mix of the potential regulatory pressure they face here in Europe and in other countries, but also direct user action and direct appeals from their users. And I think a much better understanding on the part of a lot of the staff at these platforms of the chilling effect that things like hate speech and harassment can have. That's, I think, an important thing to underscore here as we're thinking about freedom of expression. Freedom of expression involves, and I have focused a lot on kind of the risk of overbroad application of the law to silence speech, but there's also absolutely a risk of people's expression being silenced because there is unaddressed they face unaddressed harassment or hate speech. So with all of these pressures from literally everybody saying do something more about all of this content, that's really pushing towards an increased desire for automation in content moderation. My organization has done a lot of work looking at what are the different types of automation that are used in content moderation, because there are the pressures are very specific. These are not kind of speculative concerns. There's active legislative proposals and debates before the European Parliament right now on the use of upload filtering for copyright, although I guess that's not a debate anymore, that was passed, and also in the terrorist content regulation that is pending before the Parliament right now. I think one of the things that's important to keep in mind about automation is that there are many different types. Automation in some form has been used in managing online content for decades. Spam filters are a kind of automated effort to reduce the amount of unwanted content that people encounter. But there are kind of technical differences between different types of automation that kind of show the limits of what even machine learning and AI can do right now. So you have automation that essentially relies on matching newly uploaded content to kind of a pre-existing list or database of content you want to keep off of your website. A good example of this kind of effort is the work to address child sexual abuse images on platforms that's been going on for close to a decade now. There's a tool called PhotoDNA that Microsoft helped develop that is a kind of robust hashing or fingerprint matching system for files, so that you can get a kind of a fingerprint of a file from an entity like IWF or NCMEC and see if new things that get uploaded to your platform match that file or not. The companies, some of the big social media companies have also, I think as Peter mentioned, begun an initiative under something they call the Global Internet Forum to Counter Terrorism to share hashes of terrorist propaganda that they've identified on their platforms with a growing consortium of companies, so that all of those companies can potentially identify this material on their sites and keep it down. But so hashing and things like keyword filters fall into the sort of matching content with previously identified unwanted material. There's also been a lot of work done in sort of pattern or behavioral analysis as a way to do content regulation type activities. So a good example of this is, you may have seen announcements from Twitter and I think Facebook and YouTube about how many accounts related to terrorist propaganda or Russian disinformation or other kinds of kind of systemic content issues they were facing, taking down tens of thousands of accounts. A lot of times what they're doing when they identify a potential kind of reposting of an account that's devoted to spreading terrorist propaganda is actually looking at behavioral signals, not content, to identify, is this created from the same IP address? Did this account immediately follow the same list of people that this account that we just shut down was following? Is this account essentially forming the same spot in a network of something that we've previously targeted? And so there's a lot that you can do with sort of more like metadata information or signals about usage patterns to identify things like bots or people who are trying to circumvent other controls that you have. And then there's the question of machine learning and AI and sort of what is the promise of these new developing technologies for helping us get a handle on all of the other vast amounts of content that are out there. So at CDT, we did a study on particular kind of automated content analysis, natural language processing, essentially looking at the kind of the quest for, is there a tool that can help you find all of the hate speech on a social media platform? So we did a meta-analysis of a number of different studies to find that there are a lot of experiments out there, a lot of tools being developed to try to do this very complicated task of identifying what is hate speech or likely hate speech from a vast amount of social media content. But that consistently across studies, the most effective machine learning tools for identifying potential hate speech or harassment or toxic speech are very much, had to be trained on the particular platform they were being used on. That what amounts to hate or harassing content on a platform has a lot to do with the context and the culture and the specific domain where the expression is happening. So something that is hate speech on Twitter may not look the same to a machine learning tool trained on Facebook data or Reddit data or another platform. Another thing that is really clear across the different tools that people are trying to develop for identifying hate speech is, one, kind of machine learning programs do their best job when they are actually trying to approach a pretty clearly defined task. So, something like identifying parts of speech, or identifying positive sentiment versus negative sentiment may be more possible than something like identifying hate speech when, as we've discussed many times in the different presentations today, it's not always clear where people draw the line on hate speech. And in fact, what is unlawful hate speech in one country or one context may be lawful, fully protected speech in another context. So the fact that machine learning works well when it's trying to accomplish a very specifically defined task is really in tension with the kind of noted complexity of defining and talking about hate speech. There's also, as has been discussed in many different kinds of examinations of artificial intelligence, there's obviously a real risk of reinforcing existing biases in society, in your data set, whatever that is. If it's all of the posts on a social media platform, if it's a different body of training data, whatever the kind of the patterns and biases that are in that data, or the biases that are in the people coding that data to say this counts as hate speech and this doesn't, or the people who are testing the tool, or the people who are applying the tool and then interpreting the results. Along the way, there's both opportunities for humans to inject their own bias, but actually for the machine to learn on a biased set of training data in a way that creates a tool that identifies particular kinds of hate speech and not others, or is over-inclusive of posts containing a certain language and completely under-inclusive of others. And then final kind of meta point here is that shifting these questions of private law enforcement to algorithms is really shifting very important law and policy decisions about how we all in democratic societies are going to kind of respond to the fact of free speech at the scale of the internet. We have really important questions to think about and to come to thoughtful conclusions on about how do we understand the risk of overbroad censorship? How do we understand the impacts of under-inclusive kind of responses to hate speech and harassment? What do we think is proportionate when we're dealing at scale? And I think to a question I think someone raised in a previous session, what do we think about prior restraints when an account is shut down, and particularly when a lot of platforms are, finding ways to keep people from creating accounts? The account revocation question starts looking an awful lot like prohibiting somebody from speaking at all, which has typically been a highly disfavored form of restraint on speech. So with that, I will leave it there, and only a couple minutes over, open it up for questions.